You've been with your partner for 20 years. You live together, you share a bank account, you built a life together. You're practically married, right? Wrong. And that one word could cost you everything. What if your partner dies tomorrow? Do you inherit the house you've lived in for 2 decades? Do you get their retirement account? Are you entitled to anything? In most states, the answer is a shocking and brutal no. The legal system doesn't recognize practically married. Today, we're talking about the myth of common law marriage and the devastating consequences it can have on your life. Welcome back. I'm Tua, your estate planning attorney. I see it all the time. Couples who have been together for decades, who've built a life and a family, but who have never legally married. They believe they're protected by common law marriage, but in most states, that's a fantasy. And when one partner dies, the other is left with nothing but a broken heart and a pile of legal bills. Let's break down this dangerous misconception. Let's be clear, common law marriage is not a real thing in most states. Only a handful of states recognize it, and even in those states, the requirements are very strict. You can't just live together for a certain number of years and automatically become married. You have to hold yourselves out to the public as a married couple. You have to file joint tax returns. You have to intend to be married. It's a high bar to clear. And if you don't meet those requirements, or if you live in a state that doesn't recognize common law marriage at all, then from a legal perspective, you're just roommates. And roommates don't have inheritance rights. So, what happens when one partner dies without a will? The surviving partner gets nothing. The entire estate goes to the deceased partner's legal heirs, their children, their parents, their siblings. The person they shared their life with is left out in the cold. I've seen surviving partners get evicted from the home they've lived in for 30 years. I've seen them lose access to the bank accounts they used to pay the bills. I've seen them get locked out of the life they built together. It's a legal and emotional nightmare, and it's completely preventable. If you're in a long-term committed relationship but are not legally married, you absolutely must have an estate plan. It's not optional. It's a necessity. Here's what you need. 1, a will or trust. There is the only way to ensure that your partner inherits your assets. You can specify exactly what you want them to receive. 2, a durable power of attorney. This allows your partner to make financial decisions for you if you become incapacitated. 3, a health power of attorney or an advance directive. This allows your partner to make medical decisions for you if you become incapacitated. Without these documents, your partner has no legal standing. They are a stranger in the eyes of the law. What if your partner dies without a plan? Is there any hope? Maybe. You can file what's called a palimony lawsuit, which is like alimony for unmarried couples. But these lawsuits are incredibly expensive, emotionally draining, and very difficult to win. You have to prove that your partner promised to support you for the rest of your life. You have to produce evidence of that promise. It's a messy, public, and uncertain battle, and it's a last resort. Don't let a legal technicality destroy your life and your partner's future. If you're in a committed, long-term relationship, you need to have a conversation about estate planning. It's not about planning for death. It's about protecting the person you love. Thanks for watching.